Good morning to everyone. Got a great crowd here today. All right. We're going to call the meeting to order. It's just right at 10 o'clock. Patty, if you call the roll.
Al Becker.
Here.
Chip McMullen.
Here.
Doug Melton.
Here.
Rusty Moss.
Here.
Chris Racy.
Here.
David Vandergriff.
Here.
Wes Ward.
Here.
We have a quorum.
Thank you, Patty. All right. The first thing we want to do is approval of the February commission meeting minutes. Are there any additions or corrections from any commission members? Do the approval. Motion to approve. Is there a second? Second. All right. The second. All in favor, say aye. Aye. All right.
Have you approved and seconded?
Doug approved, and David seconded. All right. The next thing is our Chief Administrator report. Caleb, good morning, sir.
All right, good morning, commissioners. I was asked last time I was here to make sure I did my level best to talk directly into the microphone. So I'm gonna do my best. We'll see what we can do. Good morning. Good to see everybody here. Good to see everyone that's joining us. We're glad to have everyone and host everyone here at our E&E headquarters, and look forward to a fun and full agenda. So a couple things I want to touch on. I will endeavor to be brief because I know we got a lot of business to get through today, but there are some things that I want to be sure that we share with the group. So first, I wanted the commission to be aware, I think you're aware, but I wanted to let you know that we have just completed our second round of pre-draft stakeholder discussions on our nutrient trading rule. I know that Commissioner Melton had asked some questions about this in the recent past. And so what we have done is we have a pre-draft version of the rule to make sure that we had surfaced some comments and particular areas of interest before we actually go through the formal initiation process. We met with stakeholders that have been interested and have expressed interest in the rule in the past iteration and in the intervening time, and had a discussion last week or the week before last in Northwest Arkansas, a good, robust discussion with stakeholders. I guess it was last week. And then we had earlier this week, we met here in this room, not quite as well attended as this meeting, but we had quite a few folks that came and had a really good discussion. I think positive information sharing opportunity informed what we're going to do on working on a draft version of the rulemaking. So our next step is we are collecting all that information. We've given the stakeholders to the beginning of next week to submit any edits or suggestions or other things that they want us to have in mind before we look to initiate rulemaking. We'll get that consolidated and move forward with our internal review and then on to the governor's office. And then so hopefully in the near future, I'll be back here before you, or one of our team members will be back here before you, sharing a draft version, a revised, updated, perfect draft version of Rule 35 to come for you guys. So that has been moving. I will let Commissioner Melton in particular know that we have several of the stakeholders we met with who share his passion and sense of urgency for this moving forward. We let them know, and we'll share with you all that we hear you loud and clear. We really want to move this forward because we think, one, it's going to be good for watersheds in the state, particularly in Northwest Arkansas, where there's the most interest and most immediate desire for projects. But we just think it's going to really help us in our overall approach for water quality in the state. So stay tuned for that. It is moving. We are right now waiting on some of those pre-draft pieces of feedback, and we have blocked out time to turn that around quickly. So we do have an internal review and a governor's office briefing and some other things we will do as part of that before it gets to you, but those pieces are in motion. Also want to let you know, because it was probably last time or time before last I was here, you all approved the proposed rates for the tire districts, for the used tire programs under their newly formed, the 4 programs that are, I just did 3, but there's 4. That kind of morning. The 4 programs, what their new rates are. So after you all approved, that went to the Legislative Council and it was approved there. So those rates became effective, and we notified the districts as of April 1st. Those are effective. So at the beginning of this quarter, they will see payments. So it's the first month of the quarter. So kind of this summer, when we make the next round of payments for the second quarter of this year, this calendar year, they'll see those revised amounts go into place. So anyway, thank you all for your work on that and your approval. I wanted to let you know that we had shepherded that all the way through. We'll mention very briefly, because you may have seen some things in the news, particularly in recent weeks, and earlier this week, EPA has announced final, or I think everything they announced this week is the final, some rulemakings that they're doing that hit really for us across all media. Those are under review. I don't know as of right now how many things we will have items to come before you for approval, but there has been a lot of attention on some of the rulemakings and things that EPA is doing. We'll keep you apprised if there are things that we need to take additional steps, updated rulemakings or state implementation plans, those sort of things. But we have seen a bit of that in the news lately, and anticipate for the next few months we'll see things, because there's a lot of draft rules that were put out in the recent months that should be ready to be finalized. There's several that dealt with coal-fired power plants, and some other power plant rules were put out there earlier this week, hitting on the water, for us, the land resources, and the air side. So those are all under review. We'll share more as we go, but I know there's a big splash from EPA just because it was multiple rules they tried to finalize at once. Wanted you to be aware of that. The final thing I'll mention is that we have, on the personnel front, we have had a change I wanted y'all to be aware of, because you may see a familiar face in a slightly different role in the coming weeks, or a new face, depending on how it goes. But Jared Zweifel, who has been our Associate Director for the Office of Land Resources for the last 5 or 6 years, He has transitioned to another role within the agency, really focused more on the technical side, and doing some of the technical work with his background as a geologist that he wants to dig into some more and a little bit away from the administrative side. So we're in the process now. We appointed Bailey Taylor, who y'all have had up here presenting before. She's serving as our interim associate director and Office of Land Resources. Secretary and I are evaluating and on the lookout for a new full-time associate director. We will update you as that happens, or as we make that final decision. But Bailey had been the deputy in land resources prior to some other roles she's had in the agency. So she is a good, steady hand leading that team, but did want to share that with y'all. And I anticipate on the nature of some of the projects Jared is working on, y'all may hear from him still from time to time, but did want to make everyone aware of that. And we're appreciative of his service and his leadership that he's had for land, because we've had quite a number of projects, and he's done that for a good length of time. So we're pleased with that. And unless there's questions, that's all I have.
Any questions from any of the commission members? Thank you, sir. Appreciate it. All right. Next on the agenda is our public comment period. Judge Moulton, would you kind of review our guidelines on that?
Mr. Chairman, I don't know how many cards you have total.
I think we've got seven. We got seven.
Seven. We can go ahead and give each individual 3 minutes. I know that we have a few pending matters out here that may have folks in the audience that are parties. In terms of Pinnacle, I'm not certain if any of the cards that you have are going to be individuals that are parties to that proceeding. We might need to ask before they start if they're a party. And in terms of the stay in Echo Vista 1, the only parties that are in that proceeding would be Mayor Russell and the city itself. And I know the mayor is already completely familiar with how the process works. So 3 minutes aside, bring them on up, and we'll ask whether or not they're a party initially, and I will keep the time.
All right, sir. Thank you. All right. Handed the cards in no particular order. The first card I have is Mr. John Killingsworth, sir. Are you here?
My name is John Killingsworth. I'm a resident of Roland, and I did want to speak about the Paradise Valley wastewater treatment plant.
All right, sir. Are you a party to this proceeding at all? Are you a member of one of the petitioners?
I'm not sure that I can answer that question. Yes, I am.
Charlie, you're going to let you talk about this.
And what are you going to be speaking to, sir?
About the permit for the Paradise Valley wastewater treatment plant.
Mr. Mays, is he one of your clients, or Mr. Nolan, one of your clients? Yeah. I'm sorry, sir. We have a prohibition in our rules that if you are party to a proceeding that's pending in front of the commission, that you can't participate and address the commission during public comment. So unfortunately, the rule prohibits you from commenting. Yeah. Okay. Thank you.
Okay. Next card, Christy Eanes, E-A-N-E-S. Is that correct? Did I say your name correctly? All right. Welcome, Ms. Eanes.
So much. I'm Christine from Italy. And
I'm just going to ask you the same question.
Yes, I probably would also be a party.
Okay.
I did write a written comment.
Are you part of the coalition, ma'am?
I'm a member.
Yeah. You really.
So, okay, that's
Unfortunately, the
fine.
rules prohibit you from commenting.
Will my written comment be read by the commissioners at some point?
There are comments galore already in the record, and I recognize your name because I read the comment. So, yeah, unfortunately, until they finally make a decision in this matter, because you are a party, our rule prohibits you from commenting.
Of course, no, I understand.
Yep.
Thank you.
I'm sorry.
No, thank you.
All right. The next one is, I think is it Marty Buchanan? Is that correct?
Yes.
Good morning, sir.
Good morning. My name is Marty Buchanan. I'm a
I'm going to ask you the
resident.
same question. Mr. Buchanan, are you a member of the petitioner group or any of the people that are involved in this today?
No, I'm not. And
Okay.
I'm
All right.
here specifically to speak about the expansion of the waste management facility in Town.
Okay.
My concerns revolve around the groundwater, and that there have been some concerning dye tests about where this groundwater is ending up. And it's also my understanding that there's not really good information on what dangers, if any, this groundwater poses to both the citizens and families of Town. So while I am not specifically opposed to an expansion on principle, I feel as though it wouldn't be very prudent to authorize an expansion of the facility until we had some definitive answers on both the nature and the location of the groundwater that exits the facility. So those are my concerns. I would respectfully request that any expansion be delayed until some extensive testing can be done to where we have a very specific determination and answers to those questions. And that's all I have today.
Thank you
for
so
your
much,
time.
sir. Appreciate your comment. The next commenter, Al Drinkwater.
Just right quickly, I just want to thank the commission, the department for the work that's going on with the nutrient trading program. I think it's a great program. It has an opportunity to really get a lot of things out of our watershed that we wouldn't be able to look at if it wasn't for this. And I think it's got a great future in Arkansas. Thank y'all.
Thank you, sir. The next card is Kenneth Lovett. Mr. Lovett. Mr. Lovett, same question for you, sir. If you're a party, please let us know who this is today.
No, sir, I'm not for it.
Thank you, sir.
Mr. Milton, can you hear me? Can you hear me? Awesome, thank you. I'm Kenneth Lovett. I'm here to talk about the Eco Vista expansion, air quality and water quality. Have any of you ever struggled to breathe personally? Can't answer? Okay. Our system was broken. Acrolein, identified by National Guard, has side effects that have been have been occurring to me since December 29th, 2021. The following is from the Center of Disease Control and Prevention. Inhaled acrolein is highly toxic. Acrolein is irritating to the upper respiratory tract, even at low concentrations. Its odor threshold of 0.16 part per million is similar to the OSHA permissible exposure limit, 0.1 parts per million. Thus, odor may provide an adequate warning for potential hazard concentrations. Acrolein vapor is heavier than air. Thus, instead of being dispersed into the atmosphere, acrolein goes down into the community and exposes citizens every day. The vapors that are emitted from EcoVista can be neutralized. There's NaOH scrubbers, caustic scrubbers that circulate and neutralize the vapors as they flow through the spray column. The regulations haven't been updated in 16 years. There's DEF, pronounced DEF, is required for many vehicles, states and countries, by many vehicles, states and countries. Diesel exhaust fluid systems are required to be installed in diesel engines. The U.S. Environmental Protection Agency put this into place in 2010, but we still have engines running at this facility that do not have scrubbers on them. Our people, we keep hearing that EcoVista is being prejudiced because they can't expand or whatever, they're going to lose money. The people in Town are the one that's prejudiced against. We keep breathing this stuff every day. It's there, it's obvious. The National Guard obviously got benzene and acrolein in their latest test. And each branch of government we keep going to, that has been approached concerning the EcoVista keeps bringing up the same questions that have already been answered. And it's just an endless loop of red tape from the government. And it's ridiculous. And I don't know how to fix it, but it needs to be done. ADQ credibility is poor, in my opinion. Everybody has their own. Mr. Melton actually started his comments out. I want to play this for you.
Thank you, Mr. Chairman. You were saying the same information you said before, we still can't do anything about it.
Right.
I don't know what you think is going to change between your first presentation and this one. You have to, I would concur with the chairman, you need to get the attorneys coming back to us, it's not a solution.
The issue is, it's not a solution. But Mr. Melton himself raised a class 1 state with a lot of prejudice against the people in Town. I got a lot more here to say. I know I'm past my 3 minutes.
You're a minute past. I'm being generous to you, Mr. Levitt.
But I do have the rest of my document here. Is it okay to pass it out to you gentlemen? Sure. Okay. So I'm gonna leave it at that. I've got a thing here from Acculine, what it will do to you. If you think I'm treating you bad, it's because this gentleman right here and this gentleman right here that started it. Thank you.
Thank you, sir. Yes, sir, I got it. All right, next commenter, Rhonda Downey, if I get her name right. Downey, yes, ma'am. Welcome.
Hello.
Ms. Downey, I'm gonna ask you the same question.
I'm not involved.
All right, thank you.
Okay.
Go right ahead.
My name is Rhonda Dowden and I live in Town, and I've spoke here before. I didn't think I'd get to speak today, so I'm going to read you a letter that was published by me in the Northwest Arkansas Gazette that actually pretty much pinpoints it. Who regulates the regulators? That's a good question, because what I've been watching, they're not regulated. It's like crazy. I'm no longer upset at waste management operation of the EcoVista landfill for their bad business tactics and lack of moral compass when it comes to human health. I hold the Arkansas Department of Environmental Quality accountable 100% for the monster the landfill has become. They have created the mess we are in now and have dragged their feet to fix it. ADQ has turned a blind eye to violations committed by waste management for over a decade, refused to test water and air, notified waste management when they were coming to inspect the landfill, that's a fact, ignored serious issues like underground fires, denied gas fumes affecting citizens, and acted like the dye upstream was Kool-Aid. Therefore, it was no big deal. Folks, ADQ was formed to protect Arkansas citizens from polluters that harm folks for the sake of the mighty dollar. Now think about that. They were put in place to protect us. What I have witnessed has been the opposite. ADQ allowed waste management to gobble up 600 acres right up to the citizens' back doors, allowed expansion after expansion, holding waste management's hand at every hearing held concerning their bad practices, and refuses to fund and conduct scientific studies that should be required around an active landfill. The only thing ADQ, oh, excuse me. Okay, let me back up. I missed a spot. Let's see, active landfill. ADEQ statement each time is waste management is within the legal compliance to the state regulations. Well then, these regulations need a total overhaul and ADQ should not be a part of this process. The only thing ADQ is protecting these days is their golden egg, which is EcoVista. ADQ received $1,807,217,000 for the year 2022 from Waste Management. That's almost $2 million in 1 year. Their annual revenue is bumped about $150,000 with the tonnage with each year. It's frustrating. There is no incentive for ADQ to regulate waste management, which leads me to believe there is shady going on behind closed doors. I want every state official at ADQ, setting up here, waste management bigwigs, and the former Tawnytown officials that had a hand in this mess to keep in mind. Polluters always get caught, but unfortunately the damage is already done and it's way too late. Now, the last question I have for each and every one of you. Do you, as members of all I listed above, want your grandchildren, they think you were involved in this and did nothing to help? Please don't pass this. Make sure you test our air better and our water before you pass this. This is ridiculous and it's all going to fall back on each one of you because I'm going to make sure it happens. National news. I'm considered Gladys Kravitz of Tawnytown, the big mouth of Tawnytown. You can sit and laugh, sir, because you're going to be my first person I contact 60 Minutes about.
It's better to smile.
Thank you. Have a good day. I appreciate your time.
Thank you. Our next commenter, Mark Calcagni. Mr. Calcagni, welcome back.
Thank you all. Good morning, everybody. I'm Mark Calcagni. I live at 12642 Harbor Acres Road, and I've lived there for over 36 years. Before I talk, I want to recognize and thank some of our government officials that are here in support of against the expansion of the landfill. We have Robin Lundstrom that's here, state representative, Steve Unger, who's state representative, of course, our Tawnytown mayor, Angie Russell, and then our city council member, Amber Iberia. So thank you. I'm here today for my family and for my neighbors, along with my neighbors who have passed away, like Roy Trammell, who lived across the street from the landfill, died of lung cancer. Virginia Simcoe, whose property backs up to the landfill, died of lung cancer. Mike Burlingame, one of my best friends who lived around the corner from the landfill, died of lung cancer that spread. Tossa Russell, whose property backs up to the landfill, has a mysterious ailment that doctors cannot figure out. And Mr. Glenn Oglen, his property backs up to the landfill as well, who has been going to several doctors to figure out why he has respiratory issues and has been coughing up stuff. None of these individuals smoked cigarettes, and we don't think it's coincidental. If you follow the law, as we've heard, and pass the expansion, then the law regulation is flawed as we don't see pollution control and environmental quality. What do we know? Tawnytown City Council unanimously rejected the landfill expansion for the PC&E regulations referencing the host city almost 2 years ago, 3 times with stronger language each time. We've heard you cannot have it both ways, but I cannot find in the regulations if the host city accepts contractual payment from the landfill, it disqualifies the host city to rejection of the landfill. Maybe I missed that or I'm not adept enough to understand the legal wording. The host city incurs costs associated with having a landfill, such as road maintenance, trash, debris cleanup, police and fire protection, which have come into play. And administrative costs they also have, i.e., handling complaints. Tawnytown incurs costs to this landfill and should accept those costs or accept those payments. We know the area is karst and was determined early that a landfill should not be in this type of area. A red dye test in the proposed expansion area showed up in Wildcat Creek, which flows into the Illinois River, which is a source of Oklahoma's water. The Arkansas National Guard has tested the air twice in 2024 and found harmful gases such as sulfur dioxide, benzene, and acetylene. Again, harmful gases. There has been numerous documented complaints along with dated pictures reported to ADQ. We know this landfill is the most populated landfill in Arkansas with 12 housing subdivisions within a mile and more housing being built and more being planned for the area, and an elementary school just over a mile away. If you follow the flawed law by passing the expansion, please set a time limit of 1 to 3 years to find a more suitable location away from this residential area. If you care about health and safety, you would do just this, as this situation has worsened in the last 5 or 6 years. Thank you, and it will get worse. Thank you.
Thank you, sir. Is there any other individual here that would like to speak as public comment period? All right, thank you very much. You did. Okay, go ahead, Commissioner Melton.
Judge, Mr. Calcagney brings up an interesting point. Do we have the ability to put a deadline on how long this facility can operate? That's statutory, is it not?
I don't believe there's anything in the statute that allows you to put a deadline.
Okay, that's why I wanted to make sure. I thought that was the case.
And while all the comments, I'm not trying to undercut the merit of any of the comments, but they all basically were oriented towards expansion. And the issue that you're taking it up, which is currently on appeal before me, the issue you're taking up this morning is going to be whether or not the station be lifted or should remain in place.
I just want to make sure we don't have the ability to do that.
Not that I'm aware of.
Okay, thank you.
All right, next item of business is rule number 12, the regulated storage tanks. Mr. McAllister, good morning.
Good morning, Mr. Chair. Good morning, Commissioners. I'm here on a motion to finalize rulemaking to amend Rule 12. You'll recall we initiated this rulemaking in front of the Commission in February. This is a change to Rule 12 in reaction to conform to legislation that was passed in the last regular session. That legislation raised the cap for the amount of recovery available for remediation work from $1.5 million to $2 million. That bill was supported by the Oil Marketers Association and the other regulated community that are vitally interested in the fund and its function. That bill passed, and we're required by the legislature to amend the rule to reflect that law change. That is the change in the rulemaking that we presented to you in February. There are also a couple of tweaks to conform with some licensing certification issues in previous law that were also to conform the rule to the existing law. After we initiated rulemaking, there was public notice and a comment period. There was a public hearing. I believe Judge Moulton was the hearing officer on that public hearing. Opportunity for comments. I think the one comment we received was from the Bureau of Legislative Research, who asked about the wording of the rule change and why and how it conformed to the law. We responded to that. And so we followed the process, and we're ready to finalize this revision of Rule 12. We ask that you grant the motion and sign the proposed minute order we have presented to you. And once that's done, we will take that revised rule through the legislative review process mandated by the General Assembly. And once they've reviewed it, we will file it with the Secretary of State, and it'll be final and in effect. So if there's any questions, I'll be glad to try to answer.
Commissioners, anyone have a question? Can we entertain a motion to adopt the minute order? Commissioner Melton moved, seconded by Dr. McMillan. All in favor, say aye. Aye. Thank you, sir.
Thank you.
Next item of business, the Solid Waste Licensing Committee.
Good morning, sir. My name is Randy Harper. I'm the current chair of the Solid Waste Licensing Committee. And I have the privilege to come before you today to ask for your consideration and appointment of 2 members to the committee. One will fulfill a term that a previous committee member could not complete, and the other is a renewal. So I'll present to you Angela Sparks from Craighead County Regional Solid Waste Management District to take the position that was vacated by our previous member. And Joe Hopper with the City of Conway Sanitation would be for a reappointment.
All right, thank you, sir. Does anyone have any questions for Mr. Hopper? Any commission members? If not, I'd entertain a motion to adopt the minute order. All right, we have a motion by Commissioner Ward. Is there a second?
Second.
Second by Commissioner Vandergrift. All in favor, say aye.
Aye.
Thank you, sir.
Thanks, sir.
All right, now we're going to go to the 2 remaining matters on the agenda. We're going to have a change. We are going to move the Pulaski County Property Owners Multipurpose Improvement District matter first. Mr. Mays has another conflict this afternoon, and we want to be able to make sure he can get there to his meeting. So we're going to do that first, and then the matter about EcoVista. So Judge Moulton, I'll let you take this forward.
Lay out the ground rules, Mr. Chairman.
Yes, sir.
So it's 15 minutes aside. I know that DEQ filed the initial request for oral argument, so I would kind of defer to them in terms of how much time they need and how much time they want to allocate to the improvement district and their council. And then, of course, the other side is going to have their 15 minutes as well. First side has the opportunity to reserve time for rebuttal. Once all the oral arguments are complete, then typically what we have is just go down the line and ask whether or not any of the commissioners have any questions. But if anything crops up that is unique, give me the high sign and we'll try to address it.
All right, we can do that.
If I may.
Yes, sir.
I'm going to recuse myself since they don't want to get involved.
Yes, sir. Absolutely. All right, so DEQ goes first.
I believe Mr. Hicks is going to go first. Is that right? Well,
Mark Allison, representing the improvement district. I just want to point out that Rule 8619 H1 says that party or parties requesting an oral argument shall be allowed no more than 15 minutes each for argument. And the district, the division filed the oral argument, district did also. So I respectfully request that we be allowed to have 15 minutes each. I don't know if we'll use it or not, but that would be my request based on the rule.
I don't think I necessarily agree with your interpretation of the rule, Mr. Allison. It's up to the commission if they want to give you 15 minutes aside, but that's a lot of time because that's an hour if we go that route.
Well,
So that means you get, hold on a second, Mr. Allison. That means you get 15 minutes. That means Mr. Hicks gets 15 minutes. Mr. Mays technically gets 15 minutes and Mr. Nolan gets 15 minutes.
I believe the rule says that opposing parties of record will be permitted no more than a combined total of 15 minutes. So the parties that file a request for oral argument each get 15 minutes, but the opposing parties have a combined total.
All right, so now we're down to 45 minutes.
Again, I don't know that we'll use it.
I'm fine with Mr. Allison's request. I mean, I don't want to shortchange anybody.
Yeah, that's fine too. All right. Go ahead, Mr. Hicks.
All right, well,
So you have 15 minutes. Okay, so-
I intend not to use those 15 minutes at all
So
possible.
do I need to set a timer on you, sir?
Please, I'll reserve the remainder of my time for rebuttal.
Basil, I'm sorry to tell you, well, I've been asked if we take about a 5-minute break. So
No
we're gonna do that and come back.
All right.
5 minutes.
Yeah, Gary, I see that you, back when I was doing a lot of that. I like it. Good seeing Rachel, how are you? That's my fault. I can't say it. No one that's ready.
We're gonna reconvene now. Is everybody? Hey, good morning, Dave.
Morning.
Go right ahead. Thank you for indulgence.
Judge Milton, as I said, I'll take the rest of my time for rebuttal. I'll be brief. Thank you, commissioners. I'm going to start with the basics here. The challenge permit is an NPDES permit that authorizes the discharge of treated wastewater into an unnamed tributary of Mill Bayou. Then the NPDES permit states discharge shall be in accordance with the effluent limits, the monitoring requirements, and other conditions set forth in the permit. Effluent limits in an NPDES permit are developed to be protective of Arkansas's water quality standards and all applicable designated uses for a water body, including downstream uses. This commission establishes Arkansas's water quality standards in Rule 2 to protect those designated uses, including designated uses such as a raw source of drinking water. DEQ is bound to follow state law and this commission's rules in developing permit effluent limits that are protective of Arkansas's water quality, their standards, and the applicable uses. The ALJ found that petitioners failed to prove by a preponderance of the evidence that the permit's effluent limits violated Arkansas's water quality standards. And those standards are established to protect the beneficial uses of the receiving stream, the unnamed tributary, and the downstream waters. The administrative law judge did not order DEQ to make any changes to the permit. For these reasons, DEQ is asking this commission to amend the minute order to find that the permit is affirmed. DEQ also addressed the possibility of contamination reaching Maumelle Water Corporation's well number 1. They did that with those same effluent limits. The effluent limits that are protective of Arkansas's water quality standards are protective of the applicable designated uses, including a use as drinking water. The fact that it then filters down into the ground to get to the aquifer doesn't change that when it's at the surface, the discharge is protective of drinking water. DEQ stated this in its response to comment on that issue. It said, the permit is protective of all designated uses, including as a source of raw drinking water. DEQ submitted the analysis that the Arkansas Department of Health provided to EPA as Exhibit 2 in DEQ's motion for summary judgment. The Department of Health's memo to EPA explicitly stated Mill Bayou crosses into the wellhead protection area of well number 1. That memo concluded that the discharge was likely to have no impact on well number 1. DEQ has no objection to providing Maumelle Water Corporation with the Department of Health's and DEQ's analysis of the variables as requested in the recommended decision. We've transmitted the information to the Department of Health already. And based on what we know right now, the underlying geology has not changed. The information that the Department of Health had when it made its initial assessment and provided it to EPA is the same as it is now. DEQ asked the commission to approve its minute order for the following reasons. The ALJ affirmed the effluent limits, the conditions that ensure water quality is protected, and that uses are being met, including the drinking water use. DEQ has already provided the Department of Health's memo to EPA to Maumelle Water Corporation as an exhibit to its motion for summary judgment.
That memo demonstrates that the same geological information that Maumelle Water Corporation's expert had is the same that ADH relied on. They both knew that Mill Bayou went through the wellhead protection area. Thank you.
Mr. Hicks, you have 10 minutes extra for rebuttal, if you so desire. Mr. Allison.
Thank you, Judge. I'll reserve 10 minutes for rebuttal also. Good morning. My name is Mark Allison. I'm an attorney for Pulaski County Property Owners Multi-Purpose Improvement District 2021-2. The district echoes DEQ's request to modify the recommended decision in this case by affirming NPDES permit AR 0053210 in full. As Mr. Hicks pointed out, Judge Bolton did not overturn or invalidate any term or condition of the permit. He did not find any violation of any statute or commission rule. And the final permit complies with the law and fully protects all uses of water. The recommended decision only requires DEQ to provide Dr. Zernecki's opinion and Judge Bolton's recommended decision to the Department of Health, and then to deliver analysis of the possible impact on Maumelle Water Corporation well number 1 to Maumelle Water Corporation. And the district understands, as Mr. Hicks said, that these actions are in progress. No other permitting action by DEQ is required by the recommended decision. The way we read the recommended decision, the Judge Bolton's concern was not with the permit, but to assess the risk based on possible future non-compliance. There's no dispute in the record that the permit protects the raw drinking water uses. There were testimony by Mr. Lehmans from the department on that, and even Dr. Zarnecki agreed that he was not concerned about the permit limits. Order number 9 on page 51 at the end of the recommended decision says, this is a quote, DEQ and the district argue that the evidence and testimony did not prove by a preponderance of the evidence that well number 1 would end up with contamination. And why the ALJ agrees with that assertion, it is predicated entirely on the presumption that the wastewater treatment plant will function flawlessly and never exceed its permanent discharge limits over the next 16 years. The ALJ believes that presumption to be unrealistic, and a comprehensive risk assessment needs to include an analysis of all potential variables. And then it goes on to say that Maumelle Water Corporation has proven by a preponderance of the evidence that there was a demonstrable risk that well number 1 could be negatively impacted by the wastewater treatment plant, and is recommending a remand back to DEQ. But that could be said about any permit that's issued by the department. And the department has got conditions in the permit to address those things. This is not a permitting issue. This is a potential compliance and enforcement issue. The permit already contains terms and conditions to address instances like those that Judge Moulton expressed concern about. And the permit, by the way, is in the record at page 3,232. Part 2, condition 2 of the permit allows for the permit reopening under federal regulations if there are water quality impacts down the road. That's at page 3237. Part 2, condition 6 of the permit requires that an evaluation of the facility, the wastewater treatment facility, be done once it gets to 80% of its design limit. So there's going to be an evaluation once it gets in place, operating in place afterwards. Part 2, condition 12 of the permit has a
a requirement to report within 24 hours to the department any overflow from the plant, even if it doesn't reach the waters of the state, and quote, no matter how small. Part 3, General Condition 3 of the permit gives the department the power to modify, revoke, reissue, or terminate the permit for violation of terms or conditions, or if the permitted activity endangers human health or the environment, it can only be regulated to acceptable levels by permit modification or termination. Part 3, General Condition B1 requires that the facility be properly operated and maintained at all times. Part B, General Condition 3 has a duty to mitigate any discharge and violation that has a reasonable likelihood of adversely affecting human health. And the department has other tools to address this risk once the treatment plant is built and the subdivision is built out. So the permit already contains terms and conditions to address the ALJ's concerns. The reason we are here today is because this permit is needed now to allow the development of this new affordable residential subdivision in West Pulaski County. A new supply of affordable homes is badly needed. It has taken 3.5 years to get to this point with this permit. The initial permit application was filed in September 2020. There have been 3 draft permits. There have been 2 public hearings. There have been almost 1,200 public comments. In order number 7, the administrative law judge remarked at the sheer volume of public comments in this case. Waiting for a final decision on this simple minor permit has required the patience of Job. And the opposition here to the permit is to the development itself. Further delay in affirming the permit will unnecessarily delay these badly needed homes from coming on the market. As you probably all know, home mortgage interest rates have risen dramatically since September 2020. And during this 3.5 years of this permit process, through 3 draft permits, 2 public hearings, the developer has had borrowing and carrying costs that he's had to bear during that time. So further delay in affirming the permit will just cause further prejudice and harm. The district respectfully requests that the division's permitting decision and the permit, the right permit, AR 00533210, be affirmed in full so that this long delayed project can move forward. And I would request a motion at the appropriate time to adopt ADEQ's proposed minute order. Thank you.
Mr. Allison, you got about 7.5 minutes for a vote. I think Mr. Mays is up next.
Thank you, Judge Moulton and Mr.
Mays,
Chairman.
have you conferred with Mr. Nolan and
Yes,
splitting your time at all, sir?
Take approximately
Okay.
10 minutes and.
10 minutes for you, sir? All right, please proceed.
Thank you, Mr. Chairman and the members of the commission. First, I know you've had a hard day today. There's been a lot of criticism directed toward you. I'm going to thank you to help maybe change the tenor a little bit for reversing the order of the presentations today, because I have a hearing this afternoon in federal court, in Judge Rudofsky's court, no less, and I don't want to be late for that. I will take a minute just to tell you the purpose of that hearing is the rights, the First Amendment rights of citizens of the United States and citizens of Arkansas to appear before public panels and public commissions such as you, to voice their opinions and to do so and to exercise their First Amendment rights of petition to the government for relief or redress of their grievances, just as we're doing here. And I think that that's a very valuable and a constitutional right that we all have. And I appreciate your being here and serving and listening to all the complaints and to the other concerns that we're addressing to you. I'm representing Maumelle Water Company, which is a relatively small water supply company out near Roland. Mr. Greg Harrod, who is the general manager of the water company, is sitting there in the second row. And Mr. Dan Hernandez, who is the vice president of the water system, is also with him. I also represent approximately 12 families or individuals who live in the Roland area and who get their water supply from Maumelle Water, who are also individual petitioners in this case. The judge in this case has rendered an opinion that is approximately 53 pages long, a very long opinion. And my personal view is that he's done an excellent job of reasoning and supporting his findings. There are disagreements with it. I'm going to address the part of his opinion that deals with the the Maumelle Water System well number 1. Mr. Ross Nolan, who is an attorney here, will address the other issues that we have raised with regard to the opinion regarding the limitations of the permit and so forth. In order for you to understand our objection about the endangerment to Maumelle Water Company's well, you have to first understand that the subdivision that is proposed by the developer to be put into this area is roughly 30 or 40 acres of land on which they propose to build 300 houses, a lot of houses on a relatively small portion of land. They also propose in the future to develop another piece of land that's close by with a large number of houses. The wastewater from those houses is going to, and that's the subject of this permit, is going to be discharged into a water called Mill Bayou. Mill Bayou at this point is a relatively shallow, a very infrequent, it's called an ephemeral stream by some, in that there are frequently times of the year it doesn't have any water in it at all, and the only water that would be in it if this subdivision is put in and if this permit is approved for discharge at this particular point will be the water from the wastewater treatment plant. The water company has a drinking water well that obtains its source of water from Mill Bayou that is immediately downstream of the proposed discharge point for the subdivision. And that's the context of it. During the comment period on this permit, Maumelle Water Company submitted some comments along with other people about this very issue. And the permit itself on page 10, which has response to comments, states that several commenters expressed concern on the effects that the discharge from the wastewater treatment plant could have on the drinking water due to infiltration of the effluent into the groundwater. Maumelle Water Corporation and several commenters have asked for an impact study to the aquifer since their primary concern is discharges upstream of the drinking water wells. The response of ADEQ to that comment was this, and it's very interesting and it boggles the mind. Their DEQ's response was that DEQ Office of Water Quality has been in communication with the Arkansas Department of Health regarding the questions related to the proximity of the discharge under the permit to Maumelle Water Corporation's source wells. As understood, Maumelle Water Corporation's wells are significantly upgradient from the permitted outfall under NPDES permit number, and it gives the number, and the discharge poses no demonstrable risk to the source wells. That was ADEQ's response to my client's request for a risk assessment on the well. They consulted with the Department of Health, and they believe, and I don't know, there's nothing in the record that shows what the Department of Health provided, but according to this, ADEQ understood that the well was up gradient, not down gradient of the proposed discharge point. Well, that was quite a shock to Maumelle Water Company and to the people who live out there, all of whom know that the well is down gradient of the proposed discharge point. So Maumelle Water Company hired Dr. John Cernicki, who is a PhD in hydrogeology. He was with the U.S. United States Geological Service for about 30 years, and he's now a professor at the University of Arkansas at Little Rock. And he did a study of all this. He did quite a review of all the geology and hydrology in the area. And he testified at the hearing on this permit that one, the water well is downstream of the proposed discharge point. Two, that the water from Mill Bayou recharges the aquifer from which Maumelle Water takes its water for its wells. And three, that there is a demonstrable risk that well number one could be negatively impacted by the wastewater discharge. The administrative law judge had a very, as I said, a very exhaustive opinion on this, and I invite you to read, if you care to, pages 46 and 47 of that opinion, which has an exhaustive review of the administrative law judge's concerns about what this testimony showed. In fact, he questioned Doug Ford, who is a very reputable and very capable engineer, about the testimony. Mr. Ford was at the hearing, and the court asked him to a reasonable degree of scientific certainty, you don't have the ability to absolutely refute what Dr. Zarnecki testified to yesterday, and Mr. Ford said, I do not have that ability. Nobody has disputed Zarnecki's testimony. It stands undisputed. The administrative law judge, in his conclusion, said the ALJ believes that a comprehensive risk assessment needs to include an analysis of all potential variables, positive and negatively, that the wastewater treatment system possesses. There are others that I haven't mentioned, other issues that are presented. I don't have time to go through all that. Therefore, the ALJ finds that Maumelle Water Company has proven by a preponderance of the evidence that there is a demonstrable risk that well number one could be negatively impacted by the wastewater treatment plant, and is recommending, the judge is recommending a remand back to DEQ so that a complete record regarding that risk is fully assessed.
Mr. Mays, you have 1 more minute. Okay, sir.
Thank you, Your Honor. That means to me, and of course, the meaning of what he wrote, his interpretation, the judge is sitting here, he can tell you what he meant by writing these things. But to me, that means that the permit should be referred back to ADEQ for further analysis of the potential for the impact of the discharge on the water in Mill Creek Bayou and on the effect that it may have on the well that Maumelle Water Company has that draws water from underneath that bayou. I ask that you affirm the judge's opinion in that regard and remand the issue back to ADEQ for further investigation, further hearings on the question of whether it will affect that well, and for further proceedings if they find that it does. This ADEQ is totally wrong in their analysis of what the impact of the judge's opinion is. Thank you for your attention, and I appreciate very much your reversing the order of the presentations today. Thank you.
Thank you for recognizing me. I am Ross Nolan, counsel for co-petitioners, Pinnacle Mountain Community Coalition, and Chris Centofonte. This is a separate party from the Water Corporation that Mr. Mays represents. This group and Ms. Centofonte have been involved in this issue for almost 3 years now. Every public meeting, multiple public comment periods, and finally an administrative trial on the draft permit. They have a vested interest in their health and that of the environment in their community, including Mill Bayou. They oppose a new discharge of pollutants to a stream that is subject to low or no flow stream conditions from a facility with no proven financial plan for maintenance or operations of that facility. PMCC has raised serious factual and legal issues pertaining to this permit.
Mr. Allison, let's let Mr. Nolan finish his comments, and then if you have, well, sir,
It's overruled.
we're not in court.
Go ahead.
That time won't be held against you.
Okay. Thank you, Chairman. So what I want to note is that while the recommended decision today grants the relief that PMCC requested, remand, it is not on the grounds that we pursued at trial. So to be abundantly clear, we do support the recommendation for remand. Doing so allows the agency another opportunity to address the serious issues we've raised in the comments and at trial. What we do not support is the novel procedure proposed by DEQ and adopted by reference by the applicant. Specifically, the recommended decision calls for remand to further consider Arkansas Department of Health matters and testimony from the trial herein. While the first step in that recommended decision is to provide information to the Department of Health, which DEQ says it has done, that is only the first step. Simply providing the information does not mean it has been properly considered and incorporated into the permitting decision. That will take an additional draft and review process, which we've done several times here. Something that must be done in order to incorporate that information into the permitting decision. This is consistent with Rule 8.618C. Before you is a small packet of documents. The first attachment in that document is the response to requests for oral arguments that I've filed on behalf of PMCC in this docket. The second attachment to that document has some quotes from our post-trial brief. In short, it states that you may affirm, in short, Arkansas Pollution Control and Ecology Commission Rule 8.61C, which is quoted on page 2 of our response to comments, states that you may affirm, modify, or reverse the recommended decision. It's PMCC's position that DEQ is asking you to do something today other than affirm, modify, or reverse, which is to cut short the remand clearly contemplated by the recommended decision, thus circumventing further involvement by the Department of Health and the public on this permitting decision. That is not how these rules work. As stated at the bottom of page 2 of my response, completing remand requirements before the commission remands the permit is not a choice provided by Rule 8.618C. Again, PMCC supports remand and asks the commission to adopt the recommended decision as proposed. However, if the commission is not inclined to grant that remand, then I ask that you take a serious look at some of the issues that we have raised at trial that the recommended decision does not, at this time, recommend remand on. Chief amongst those, and I wish I had more time to elaborate on these, but I do not, is the fact that the Arkansas Department of Environmental Quality does not do an anti-degradation review when it issues the water permit. It just doesn't. And you can see the quotes that I've excerpted in the second attachment from our post-trial brief. They use the same boilerplate language for anti-degradation review for hundreds, if not thousands of permits. This is not anti-degradation review, which requires, when you have a tier 2 stream, as they say this one is, to conduct an important economic or social analysis of the need for further pollutants in a stream and consider alternatives. You can see the testimony there. It didn't happen here. It did not happen. This is a huge issue. It's telling in Mr. Hicks' opening that he discussed permit limits and existing uses. There's a third leg on the stool of water quality standards, and that is anti-degradation, and this agency doesn't do it. I don't know how else to state it clearly. We've also raised an issue with a specific permit limit. The fact that they do not have the money to fund this facility, you'll see in there that Boyd currently has zero money and no way to fund maintenance. And finally, that when this permit application was transferred to the current applicant, that applicant didn't exist. It's our contention that this applicant has never applied for a permit. Now, if I can have just a few more seconds, Your Honor, I'd like to address the finality issue in a proposed minute order that I have at the end of our response to the request for hearing. And this is just the mechanics issue. I know we have some practicing attorneys up here, and finality and how to appeal scares us to death when there's an issue. There is no rule in Rule 8 to contemplate the position that my client is currently in that we are getting, the recommended decision recommends remand, but not on the grounds that we sought. We can't appeal unilaterally right now because we can't take a permit up if the recommended decision is honored and it stays here. We can't take our issues up. Well, I believe we can only bring our issues on appeal if the applicant also appeals, if that makes sense. So I am asking for a very simple minute order that the applicant declare their intent to appeal to circuit court within 5 days before the deadline of filing their notice of appeal, just simply so I will know if I need to also file a notice of appeal on that 30th day after the final order is issued. So that's just a mechanics thing. I don't think Rule 8 contemplates the situation we are in. So I'm hoping that a simple solution of a notice in the record would solve that. If that makes sense.
You're out of time, Mr. Nolan.
Thank you, Your Honor. Do I stay for questions?
Nope.
Okay.
All right, Mr. Hicks. Ten minutes, Basil, 10 minutes.
I hope not to use that. I just want to address the issue about a demonstrable risk. Demonstrable means you can identify it, you can point to it, you can say, this is the exact risk. The testimony, and this has all obviously been briefed up, it's in Judge Moulton's order, it's in our post-hearing briefs, but Momo Water Corporation's expert testified that it's possible that some dissolved contaminants could reach the aquifer if they reach mill bite. What he could not say with a reasonable degree of scientific certainty is that those contaminants would reach the aquifer. So he said there's a possibility, but it wasn't demonstrable what that would be, and he could not identify a particular pollutant that would reach that aquifer in a concentration that could cause harm to the well. That evidence was not presented by their expert. When asked to kind of confirm his testimony, he said, I would prefer to answer it as any water that has entered in the alluvium, that is the alluvium geological structure that Melbio flows through on its way to the Arkansas River, from the treatment plant will recharge and likely be intercepted by the well. But that is a different question than whether or not that water is contaminated. In other words, he acknowledged that the contamination issue, which is the issue that leads to the demonstrable risk, was not his testimony. He did not go that far. At this point, I'm going to leave anything else for questions. Thank you.
All right, thank you, Mr. Hicks. Mr. Allison. About 7.5 minutes, sir.
Judge, my objection to Mr. Nolan's argument was based on the fact that neither PMCC or Maumelle Water Corporation filed a request for oral argument. And because they did not, the argument here today is limited to the request for oral argument presented by DDQ and the district as to whether the recommended decision should be modified so that the permit would be approved in full for the record, for the reasons I explained earlier. So that was the basis for my objection to Mr. Nolan's discussing the other issues in the case that they did not file a request for oral argument about. Now, going down my list, Mr. Mays talked about future phases of the development. Those are going to be
Those will have to get new approvals from both DEQ and the county. So that's not really an issue here. Mill Bayou is not an ephemeral stream. It is a swamp that many times is dry during the summer. There was discussion about infiltration into the aquifer, but the point is the permit protects drinking water uses, raw drinking water uses. Everyone agrees to that. Even Dr. Zanecki agrees to that. And so it doesn't matter whether that water reaches it through a surface connection or a subsurface connection. The permit is protective of that. Judge Moulton's concern was situations where there might be a permit non-compliance. And as I explained, the permit also addresses those because it has conditions in the permit that allow DEQ to deal with that situation. Talk about Nolan's. Again, Mr. Nolan argued that there's no ability under the rule to do what the department and the district are requesting, i.e. to modify the recommended decision to affirm the permit in full. But the very language of the rule says that the commission can reverse, remand, or modify. And that's what we're asking. So that the commission does have the authority to do that. And finally, with regard to Mr. Nolan's request to shorten the time for a potential appeal by the district, I don't know what the district's going to do, but I don't think that the commission has got the ability to do that in the middle of a permit appeal proceeding. That is something that could be done in a rulemaking proceeding if Rule 8 needed to be amended to do that, but I don't think the commission's got the authority to do that in a permit appeal proceeding. Again, this permit has been going on since 2020. The opponents want one more bite at the apple, a fourth draft permit for a relatively simple wastewater discharge permit that everyone agrees meets all the rules and requirements, is protective of all uses. And so because of that, and because of the harm and prejudice that would be done to the developer by continuing to delay this, costing him time and money, and watching mortgage rates go up for this development, we respectfully request that the permit decision be affirmed in full. If there are issues that come up down the road with possible impacts on the well, those can be addressed. But we need to get some finality on this permit proceeding. And so I would request again a motion to and a vote to approve the DEQ's proposed minute order. And also the permit number needs to be changed in the minute order regardless of which one is involved because it's the wrong permit number. Thank you. Any questions?
Well, Mr. Chairman, typically what you do is you go down the line and I would say you would start with Commissioner Racy. Yes, sir. And then just move on down.
Good. Commissioner Racy, if you have any questions for any of the attorneys?
I don't think it's for the attorneys, but I do have a question or two for the judge.
Absolutely, Commissioner.
Okay. Can you state orally your position on the minute order and exactly what that option would mean for the commission?
In terms of DEQ's minute order or in terms of my minute order?
Your minute order.
My minute order? My minute order is a remand back to DEQ to ask that study that, apparently may have happened, I don't know, but it never made it into the administrative record, be conducted, and then made part of the administrative record. And the reason being is right now, the only thing that I saw in terms of the Department of Health's analysis was twofold. One was, as Mr. Mays acknowledged, the response that DEQ gave to Maumelle Water Corporation's comment about asking for a study. And the response back was, you don't have to worry about it because the discharge is down gradient and your well is going to be fine. And then the thing that Mr. Hicks mentioned was a I don't even want to call it a memo. It's a paragraph type email to EPA where Department of Health essentially said, you don't have to worry about this discharge. It's too far away from your wellhead to worry about. That was the extent of what I read and what I saw from the Department of Health in the record. The concern is, as I've articulated in the recommended decision, is that sufficient? Is that enough? Is that really truly a robust risk assessment? Because we've seen a risk assessment. That's part of the record as well in terms of we have all these septic systems that are nearby. The Department of Health has determined that they pose a demonstrable risk to this well. If the septic systems do and it's locally recharged, then I believe that the discharge from the treatment plant also poses a risk. I just don't know what that risk is because I haven't seen a study. So the remand would be for a study and then have it be incorporated into the administrative record. That's my recommendation.
Okay, that's helpful. Second question, there's been a lot of information presented today. We've received several additional packets of information. Obviously, the material in the backup material is robust. What are the implications of not taking action today? Is that an option for the commission beyond accepting one of the existing minute orders or modification?
Yeah, I don't know if you have the ability to punt it, Commissioner, if that's what you're suggesting.
I'm asking about options.
Yeah, it's ripe for a decision one way or the other. And it could be, I mean, it's not like Caesar at the forum. It's not a thumbs up or a thumbs down or, you know, the commission can decide what it is that they want to do. And if you don't think that my recommendation is sufficient or robust or clear enough, you can alter it and change it as you see fit, or you can accept the minute order that DEQ has submitted, or you can accept the minute order that Mr. Nolan has submitted. You have you are the final say, and you have the prerogative under rule and law to make the ultimate decision.
All right, no further questions right now, but I'd like to reserve opportunity if something sparked. Absolutely. With other questions from the commission. Thank you.
All right, Commissioner Ward, do you have any questions? No questions? Commissioner Milne?
Mr. Alex? Yes, sir. You said something that is very disturbing to me, and I would like for you to elaborate on it. I'll set the ground on that. There's some folks in this room that think I'm the Antichrist already. So.
No comment.
To that end, as I understood your statement, you intimated that the concerns expressed here are permitting conditions. And if something happens later on down the road, we can make an enforcement issue.
That's correct.
Is that correct?
Yes.
Okay, so here's where I'm going on that. If we're presented with something later on down the road, damage has been done. And I have all sorts of reservations about what your client is proposing here. And I'm going to get to those in a minute. But if there are concerns, wouldn't the permitting sequence be the proper time to address these rather than wait till we have an issue?
Excuse me, rather than wait till we have an issue that we have to deal with? That is not protective of the health, safety, and welfare of the public to wait till something's already occurred. And specifically, the hydraulic conductivity of this aquifer is about 100 feet per day. So if this plant is out of compliance for 13 to 16 days, depending on which one of the well protection radiuses you want to use, radii, you're going to have contamination of the aquifer with raw sewage. And that seems like a really rotten time to be dealing with an enforcement action when you could resolve some of these issues during the permitting question.
Well, let me say, first of all, that just because there's a permit violation does not necessarily translate into an adverse impact on the environment or on Maumelle well number one. I understand the concern, And my point is that you could have those concerns about just about any permit that's issued. This permit, I don't think there's any dispute that this permit, the permit itself meets the requirements and has the terms and conditions, effluent limits that protect all uses of the water quality that are involved. The issue is a non-compliance issue. And my point is that there are already conditions in the permit that address that. And those conditions are in virtually every permit I would expect that the division, can't call it the department, that the division issues. And so point is, we've been through this now for 3.5 years. And we're never going to have a perfect permit for the petitioners. And there are mechanisms in place in the permit to address the concerns if something happens in the future. I just, at some point, the delay in the process becomes prejudicial and harmful, not to the other side as well. And we just think that the permit is well written. It's got provisions in there to address the issues if they come up. And I understand Dr. Zarnicki's testimony, but I don't think there's testimony in the record as to, my understanding of what he testified to was that there was a possibility that the water could get into the alluvial aquifer, but he had no testimony about whether any pollutants would get into the alluvial aquifer. It's a mile away from the discharge point. And anyway, so our request, as I said, is that that the commission go ahead and approve the permit in full. We can, if there are issues that come up in the report, those could be addressed down the road. If there are issues that come up after the wastewater plant gets into operation, those can be addressed as well. And so that's our request to the commission.
Thank you, but I would disagree with you. 13 days after a discharge of raw sewage into this flat ground, there will be an issue and it will be recharging that aquifer. And so that's an issue I have, but thank you for your response.
Thank you.
Mr.
Hicks.
You want to.
Oh, well, I believe you are a trained geologist. Is that not correct?
Geologist and engineering.
Excellent. I just wanted to bring a little bit more science into this and make sure you understood the testimony that I heard at the hearing, which is Dr. Zarnicki said suspended solids were not going to get to the aquifer. He said those would filter out. Bacteria, he did not think would get to the aquifer. The only thing he thought were pollutants that were dissolved. And he agreed that things like ammonia would react with oxygen and likely not get there because they would react before they got there. The only thing that we had a little bit of disagreement about on what could actually get to the aquifer was residual chlorine that had already been deactivated as chlorine, as chlorine, but those residual chlorine particles that were dissolved in the water could possibly get to the aquifer. That's as close as we got to a pollutant. And they do treat their water with chlorine, so there's going to be residual water in the chlorine. So I just wanted to be clear, we did look at the science on that with Dr. Zarnicki's testimony, and that's why we're willing to say, not only are your water quality standards that you put in place that we have to abide by protective of downstream drinking water sources for surface water, in this instance, they are also those permit limits are also protected. There was not testimony that, a violation of the fecal coliform bacteria limit would cause fecal coliform bacteria to get to the aquifer. That wasn't part of the testimony. So
and that's exactly what troubles me, Councilor.
Yeah, and that's what
that's exactly my heartburn on this is that Dr. Zarnicki went to a point and he didn't complete his analysis. And so I have a little fault with that even.
But he
So,
testified that he did not think the bacteria would get there.
and for the record, I think the chairman and I are the only two people to struggle through thousands of pages of this testimony. It was ugly. So thank you, Mr. Hicks. And very quickly for Commissioner or Councilman Mays. Good morning. Good luck this afternoon.
Thank you.
I felt obliged to say something to you so that you wouldn't feel I ignored you today.
You're spot on in your concern about this. The petitioners, that is the applicant for this, is asking you to put expediency over environmental health and safety concerns. They're saying, well, let's try it out and see if it works. If it creates a problem, then we'll fix it. But you're right that once the problem is created, it's very hard to fix. And there may be serious consequences, health consequences, if that happens. So I would encourage you to consider to approve the ALJ's recommendation on this. Thank you so much. Is that all you had?
Yes, sir.
Well, thank you.
All right. Judge, I've got a couple questions, then we'll move down.
I'm sorry, Mr.
I've got a couple questions, then we'll go. Mays, I'd like to ask you a question, please, sir. I'm just curious, as I understand this, the Department of Health has a jurisdiction in a sense also over I guess over the review of the required separations of where the MW1 is and their, I guess, protected zone around that. My question is, I guess, during the permitting process, and I've read Judge Moulton's opinion, at some point in time, possibly DEQ contacted, and also I think there was a comment in the response to comments on it, that there was a question, I guess, to the Department of Health, do you guys have an opinion on this? And their response was, don't worry about it. And if that's correct, that's the only thing that's in the record. And I'm just trying to understand, because when I read the response to comments, that would have occurred, I guess, after the draft permit had been issued. Or that's where your comment is. I'm wondering at what point in the whole process did DEQ talk to the Department of Health, if they did at all? I mean, as Judge Moulton very clearly pointed out, the record is very scant with regard to the Department of Health's participation in this.
So let me first talk about the Department of Health's authority, just so that we make that clear. We did put that in the record. They have authority over drinking water wells, and they do periodic risk assessments. They did one in 2002. They did that one in 2021 for the Maumelle Water Corporation. And they've got on their website, basically their rubric for how they do those assessments. And for each well, they set a wellhead protection area. It's a minimum, I think, of 100 feet, but they usually expand it if the wells are more, if the area around the well is locally recharged or it's more permeable, they will do that. They did it 1,600 feet in this case. They put their reports out. In their rubric, they said they have a ranking system of 1 to 10, where 1 is the most risk, and then 10 is the least risk. The most risk is, Superfund sites, leaking underground storage tanks. Second is septic systems and just non-leaking underground storage tanks, because they present a risk. But the department's very clear. These are risks that you need to account for, not things that will actually pollute it, because a properly working septic system won't do that. Just like a properly working underground storage tank should not impact groundwater. NPDES permit discharges onto the surface are down at level 6. So they're at a lower level. So we looked at that as part of our analysis of what we had gotten from the Department of Health. And so I wanted to make clear, this is part of a process that they do. Now, as far as our permitting process, they review designs and specifications, and we have a condition, I believe, in our construction permit that says they can't start construction until Department of Health approves the designs and specifications for their sewage system and collection system. So that's kind of their role in that part of it. As far as their role in whether or not the discharge is protective, our first part of our response that Mr. Mays wrote is exactly what I said in my opening, which is the terms and conditions are protective of water quality of the state of Arkansas and designed to protect all designated uses of the receiving waters, including as a raw water source for domestic, public, and private water supplies. So we acknowledge that the Rule 2 should be protective of surface drinking water, and DEQ believed that that would also be protective if that surface water then filtered down into the aquifer. So that was our first stance, but we got a lot of questions from Maumelle Water Corporation, and DEQ staff reached out to the Department of Health and said, do you guys have any concerns about this? And that's why that statement is in the response to comments that the Department of Health found that it was not an issue.
Okay, well, that's my question. You're getting exactly my question.
I wanted to.
I appreciate that, and I don't disagree with what you said in terms of what's coming out the end of the pipe meeting of water quality standards. I mean, it's the permit on that. I understand that. My question is in the protected area around well number one, in a sense, that the Department of Health has jurisdiction over, and apparently the unnamed tributary, the 7Q10 stream, runs somewhere across that.
Yes.
You called Department of Health and said, do you guys see this? Do you have an issue with it? And my question is, apparently they said, no, we don't have an issue with it. But I haven't seen that in the record other than where somebody talked to somebody and they said, don't worry about it. And my question is, did you guys get any kind of documentation that showed that the Department of Health looked at this issue and was satisfied with it?
So, and I'm going to apologize. I do not have the exact page number, but the parties did depose Mr. Lehman's. Mr. Lehman's is head of our permitting.
I understand, and Mr. Lehman's explained that he talked to somebody and
Yeah,
they said, but I'm asking, is there a document? Is there a document that has a Department of Health letterhead on it or something that says, we've looked at this and we don't have a problem with this unnamed tributary crossing the protected area?
And that is in the memo to EPA that was Exhibit 2 to our motion for summary judgment.
Okay, but I know we're getting into procedural questions here, but if it's a motion for summary judgment, it's after the fact in a sense. I'm asking, was this information part of the permitting process before the draft permit was issued?
The conversation was before the final permit was issued. I don't know the exact dates is what I was going to say, is I don't remember exactly when that conversation was. So the conversation, but what I'm saying is that there was the conversation as it was explained to me, and I don't remember if this is in the deposition. Department of Health came over with their information. There are issues about FOIAbility of information on the location of wells and specific locations of wells. So I don't think they were going to leave that information there, but they did convey what they had said to us. And since, as Mr. Levens testified, he was confident that it was protective from our discharge point. He was just checking with Department of Health to confirm, and that's what the comment reflects. I don't know that there is a requirement that we get something in writing from the Department of Health. I don't know that there's a requirement in your rules that is part of this process, but under your rules, the discharge is protective. But DEQ went a step further and said, Department of Health, do you do this? And they do this routinely when there is an intake downstream from a discharge to make sure that there aren't any concerns from that sort of discharge. And I know that they have those conversations.
Okay, thank you. One more question. Were those vulnerability assessments from 2002, I guess, were those reviewed as part of the permitting process before the initial draft permit was issued?
No, they were not, because we were not aware of them. And I don't think Department of Health brought them to us as part of their review for this discharge. We only got them because Mr.
Okay.
Mays mentioned them.
It's interesting though to me that when you contact the Department of Health initially about the wellhead protection area, if they knew about the vulnerability assessments, they said, well, we've got these assessments, maybe you better look at those. But apparently that conversation didn't happen.
I think they were just focused on the discharge and whether it would have an issue. And for the record, Dr. Zanecki said he had not seen those vulnerability assessments either.
Thank you, sir. Appreciate you. Okay, one second. Go ahead, Commissioner Melton. You have one more question.
Mr. Chase, your reference to this particular document, the health department is one that's given me a great deal of concern.
Okay.
You portrayed it as being definitive. I would say it is ambivalent at best, because they don't state with any certainty. In fact, they say it's likely not to. So there is a chance that it will influence the recharge area that well. So I want to make sure everyone understands that this statement is ambivalent. There is no guarantee. There is a possibility of it happening, and that's what concerns me.
And I understand that concern. What we found in testimony at the hearing is it wasn't demonstrable, it was a concern, but we couldn't point to anything that said, this is the pollutant that's going to get there. This is the pollutant that could be in a concentration that could get to the well in a concentration that would be harmful to anybody. And that's what we were missing. We were missing the analysis, as you said.
All right, Commissioner Vandegrift. He is repeating.
Appreciate something that the rules heard. I served 6 years on the Arkansas Supreme Court's Civil Practice Committee. And one of my focuses was not eliminating practice rules for lawyers and clients and not creating practice rules. So I'm concerned about these 3 minute orders. The department's minute order says that the EQ has provided the opinions of Dr. Thomas to the Arkansas Department of Health. Commissioner Mullen's minute order says he recommends EQ staff provide to the ADH staff Dr. Zonki's opinions, which to me those 2 things seem mutually exclusive. Have those opinions been provided to the ADH, or is it the qualifying language is Judge Mullen, so that it says so that the ADH has a complete understanding of variables?
They have been provided. Yes, as a result of the recommended decision, we went ahead and provided that information to them so that they could look at those things and start their process.
Have you gotten feedback from ADH about whether they do in fact understand the impact of Dr. Zonki's opinion?
I've gotten some feedback, but that's outside of this.
Another rules in our question. Judge Mullen,
Yes, sir.
Mr. Nolan's recommended minute order and his statements about the possible trap that they might be in, not having an ability to cross that. Again, because my deep hatred of traps for lawyers and their clients, it seems to me that point is well taken.
Well, to a certain extent, I guess it is. You know, the issues that Mr. Nolan raised, I ruled against him on all of those. And if the remand takes place, it's not a final permanent decision because you're remanding it. So I can understand his concern from the perspective of is he going to get, you know, hamstrung in the process itself. Although I'm not even certain who mentioned it, but in terms of altering the time frame for appeal or expediting it or things of that nature, I don't believe we have that ability as the commission. It's just the way it is. Unfortunately, I guess I've written an order that nobody likes. So I don't know if that means it's a good order or not. I suppose if you write an order and nobody's happy, then it must be a pretty good decision. But I mean, I appreciate it. I don't know whether or not there's a fix, because I disagree with Mr. Nolan that we have the ability to control timeframes on an appeal. I mean, they're set forth in statute. Under the statute. It's 30 days after a final decision. Now theoretically, he could, if you, whatever minute order you sign, that's final. Okay.
I'm not asking to change the 30-day deadline. I'm asking for a letter from any appealing party 5 days before the deadline, and then we can all file our notices of appeal. I don't have a right under our rules for cross appeal or counter appeal. I don't want their notice of appeal early. I just want a heads up. And it's a compliment to your order, not an alternative.
And I don't know if the commission has the authority under rule of statute to do what you're asking, Mr. Nolan.
To just direct an appealing party to send a letter, like that is very, very simple. And I tried to avoid the 30-day deadline for the notice of appeal because that's statutory.
I understand, I appreciate the concern as well as Commissioner Vandergriff. I do. I just don't know whether or not there's a legal fix for your conundrum. Really, I really don't. I mean, I don't think we have the authority to tell a party, okay, give us a heads up when you're gonna file an appeal. If I did, I'd love to have that.
It's just a letter. I'm not asking to change the notice of appeal.
I understand. I'm sorry, Commissioner Vandergriff, did that answer your question?
Sorry to interrupt, but I'm going to take advantage of your kindness. Does anybody have a question they want to ask me before I leave? Ross, do you have anything? All right, well, thank you for your time.
You have a question? Yep, all right. Mr. Moss, do you have any questions, sir? No questions. All right, do you have a question, Mr. Miller?
Judge, going back to Mr. Nolan's concern, can we reject part of your proposed minute order and preserve his right to the timeliness?
Can you reject Mr. Nolan's minute order and still preserve his rights? You could reject my minute order.
Yeah, I know that, but is there some way?
Well, if you I guess it depends on how you
preserve his opportunity there.
Yeah, I guess it depends on which minute order, which minute order you accept. So let's just say, for the sake of argument, you accept GEQ's minute order. I know at that point in time, Mr. Nolan's going to appeal. DEQ is not going to appeal, and neither will the district, because they've achieved what they wanted. So that will address completely Mr. Nolan's concerns, and he will appeal that right up to circuit court. In terms of my minute order, if you wanted to, I mean, certainly you can amend it or alter it or change it however you want. If you don't think what I've got in there has been sufficiently fleshed out in terms of what the remedy should be, you certainly have the prerogative to alter that remedy. If you think what I've decided is right, but you don't like what I've told them what to do to address it, you can do that as well. Now that may, depending on what you put in that minute order and how comprehensive that remedy may be, that may address Mr. Nolan's concerns. But again, I don't have a crystal ball because I don't know what you're exactly going to do.
Well, my problem with that is the standard review. If we grant the DEQ's minute order, Mr. Nolan can appeal, but what's the standard of review versus
entering his minute order if that's what we decide.
Standard of review is going to be the same regardless, and it's going to be substantial evidence, which is any evidence in the record that the commission has reviewed and looked at that provides some substance, some evidence for their decision. That's what's going to control. And substantial evidence is like one of the lowest burdens to meet. I would hope that as Mr. Mays said, the recommendation is exhaustive. He probably should have said the ALJ is exhausted, more than exhaustive. But there's enough in that recommendation, I think, for you to decide if you accept the findings of fact and conclusions of law, which I don't think anybody, well, I shouldn't say that, Mr. Nolan's disagreeing with it. But I think Mr. Mays, to a certain extent, was agreeing, at least as it relates to his client. And certainly the district and DEQ, I never heard an objection that the findings of fact and conclusions of law were frankly flat out incorrect. They don't like the remedy.
All right, any other questions, commissioners? All right, does any commissioner wish to make a motion with regard to adopting the recommended decision of Judge Moulton or something in the alternative? Commissioner Melton, you have something?
I've got copious notes here about things that bother me in this. My first gut instinct is to throw the whole thing out, but I think it's salvageable. So I have had the misfortune of falling on after things that weren't properly vetted the first time around. And it's not particularly with the health, safety, and welfare of the public, and it's extremely expensive and very discouraging to try to fix these later on. And Mr. Hicks, I know disagrees, but I just don't think that this has been given proper analysis. And I think the judge is going in the right direction with this. And so I would like to specifically ask for this to be remanded and request a site-specific hydrogeologic study addressing the probability of the aquifer contamination. I'd like a detailed engineering evaluation of the proposed package plant and its service line. That's a real issue in my mind. Repurposing things is always a good idea, but there are enough package plants that I'm familiar with that have gone south and caused all sorts of grief over the years, that this is a critical component of this. I'd like to see an economic analysis of the package plant life cycle costs and whether the POA or whatever entity has been formed can properly manage that. And then a cost comparison of alternate wastewater disposal alternatives in here. And another hearing.
All right, so Commissioner Melton, are you making a motion to accept the recommended decision with those additions?
Yes, sir.
Is there any way that, so do you have a list in front of you?
I do, sir.
Can that be made part or as an attachment to the recommendation?
Yes, sir.
All right, I think that's your motion, Mr. Chairman. I don't know if you have a second.
I'll second it.
Second by Commissioner Vandergriff. Is there any discussion among commission members? Commissioner Racy? Commissioner Ward? All right. Commissioner Vandergriff, a comment? Commissioner Moss? All right. Patty, will you please call the roll?
McClellan. Doug Melton.
Aye.
Trustee Moss. Chris Racy.
Aye.
David Vandergriff.
Aye.
Wes Moore.
Aye.
Thank you. So, as I understand it from the vote, that we have the recommended decision has been adopted along with the additions as stated by Commissioner Melton. So this docket is not closed. As I understand it, Judge Moulton, once this information is added to the administrative record, at that time, then the parties will have the opportunity to review and file whatever pleadings or.
Well, I've never done sort of a comprehensive remand of that nature, but I think what we can do is go through that process. And then once all the information has been gathered and submitted, I will go ahead and send out, another notice of hearing in terms of scheduling another hearing on those issues.
The hearing will be on those specific issues as to the additional.
That's correct. What Commissioner Melton just elucidated in his additions to the recommendation will be part of the hearing.
All right. Okay, that's, with that said, this matter is concluded. We will move on to the agenda, but I'm going to give us another 5-minute break.
All right, we're off the record for 5 minutes.
So I want to
Not me.
So we took the list. We're gonna go to the universities. Yeah. I think. Maybe right now. I'm glad you did. I didn't even know you were here. Well, they would let you go. It's your part. Well, that's right. I mean, you don't. Oh, no. You're all the time. Yeah, I retired. So I didn't go to the farm actually. I left. I know you know Jim Henry. Jim had one day. We got so much more work done. I was kind of phased out of flying work. So I worked for 5 years. Then I retired. This is all I meet the same one. We got
Thanks again. Good to see you.
Thank this. You have to run the rest of the oh, boy. Wow. We're gonna have we could reconvene. Thank you. All right. Okay, the last item today on our agenda is the request for lift of automatic stay of Eco Vista LLC Class 1. I think Mr. Heister, everyone, also for the record, I know I've said this two times before, I guess, but I always want to do it whenever this comes up and I'm here. Both Commissioner Vandergrift and myself have a conflict of interest in this matter, and we have been recused out of it since day one, and will not participate, will not vote. I mean, I'll chair the meeting, but I won't have any comments, any questions, and we will not, as we have not done in any part of this matter, have any participation in it. So that said, Mr. Heister, good morning, sir. Good afternoon.
Thank you, Chairman Eckert. My name is, like I said, Michael Heister, here on behalf of EcoVista LLC. I think I have a quick, little visual presentation, to go along in support of EcoVista's motion.
Mr. Heister, how much time are you gonna take? Not to rush you, sir, but
5 to 10 minutes.
perfect. Thank you, sir.
I think the commission is quite familiar with the EcoVista Class 1 landfill location. It's in Northwest Arkansas. To briefly reorient ourselves, see if I can. There are no other Class 1 landfills in Northwest Arkansas. The nearest one, and I know this is information we provided before, is in Fort Smith, Arkansas, and specifically the Class 1 expansion area under discussion is sandwiched in between two existing Class 1 areas. It is not an expansion towards the outside of the site. It's actually a contraction back towards the center of the site. Class 1 material for the audience's benefit is non-hazardous household, commercial, and industrial trash. It is what you put in your garbage can when you leave it out on the curb once a week. That is Class 1 material, and that is predominantly the waste that is disposed of at this Class 1 area. You may recall back in September of 2023, I came before you. The permit had been issued by DEQ, and we requested authority to construct and operate using the new space. The commission granted us authority to construct, but denied us use of the new space authorized by the permit. So in the intervening 7 months, EcoVista has been undertaking the construction that the commission authorized and has completed it. And I'll show you this red area is unfortunately not showing up very clearly. So what I'm going to do is paper copy, follow along. Take note. I'm not taking that. So the current slide we're looking at shows the landfill footprint. The area in red is where new space has been constructed based on this commission's authorization from September of last year. And immediately to the south is old Class 1 landfill space, and to the north is Class 1 landfill space. So the only Class 1 area additions being authorized by this permit are basically in the valleys between what are spaces that are already being used or have been used for Class 1 disposal. And and this is important, if the commission hadn't granted that authorization to construct back in September, there would be no solution today for the domestic trash disposal in Northwest Arkansas. The space simply would not be available, and where transporters would take that material is unclear. What is clear is that it would be farther away considerably farther away, it would be more expensive. And the same truck that currently can take several loads of your household trash to Ecovista in Northwest Arkansas is now only able to take one load of trash, because maybe you can take it to Fort Smith and wait in line there, or maybe it has to go further. So just so you can kind of see what was done, this is the valley to which I was referring. And here it is in the early phases back in the fall. What you're looking at is a Class 1 landfill area. And where the picture is being taken from is the other side of the valley that is also a Class 1 landfill area. The next page is just simply further along in the construction. The commission has Rule 22.425. It imposes special design requirements on Class 1 facilities in Northwest Arkansas. So the commission requires it to have 2 liners instead of 1. It requires a leak detection system to be in between. So if the first liner should ever leak, the leak detection system detects that, alerts the operator before any sort of anything has happened to the second liner, which would also have to somehow leak in order for anything to actually escape, any leachate to escape the landfill. So that's the first of the 2 liners that have been installed. And these pictures are taken from what's called a construction quality assurance plan. It's an engineer certified document. It's well over 500 pages long, and it was filed with DEQ kind of a couple of weeks ago. It's certified by a professional engineer that the work required for the liner has been constructed in accordance with the design requirements. And if you can turn to the next slide. Yeah. Here's just a little bit further on. Again, you can see where the valley between the 2 Class 1 landfill areas is in the process of being lined. I believe this is actually still just the first liner with the leak detection system there running down the center. And so another liner would go on over on top of that. And there are additional design requirements. Impermeable clay. Clay is not impermeable. It is resistant to water intrusion. I want to be careful there. There are also layers of clay underneath, built on top of it. The commission's design requirements are quite stringent, and no one has challenged in the underlying permit appeal whether the requirements of 22.425 have been satisfied. Yeah, that is not an issue on appeal. If you could please go to the next slide real quick. So this just backs us up for a minute to reorient. You can see the white kind of hashed area is the valley where the liner we just saw is being installed, and the red outline would be kind of the footprint of the new is a new permitted area authorized by DEQ. As you can see, it's all either over existing Class 1 landfill space, or it's basically over this line valley. Next slide. I know the commission is familiar with this. It's the same legal standard that we are subject to when Ecovista asked for and was granted relief from the automatic stay with respect to the Class 4 landfill area. The commission rule allows for a grant of a stay. Of relief from the stay, kind of where substantial prejudice has been shown. And the next slide will show you that an adverse economic impact is defined by law as substantial prejudice. And If you could turn to the next slide, please. We've again filed with the commission testimony under oath from Mr. Carl Simmons, and Mr. Simmons explains some of the voluntary measures that EcoVista undertook to reduce the volume of Class 1 materials accepted by the landfill to basically prolong its life under the space that was authorized, that was still authorized under the old permit. That resulted in reduced fees. And now we're looking at, in the next 2 weeks, the landfill will need to close to Class 1 material. EcoVista has submitted an affidavit that establishes adverse economic impacts. So from a legal perspective, the legal requirement for a stay, is satisfied. And the commission only has two options today. The commission can adopt EcoVista's proposed order and maintain waste service in Northwest Arkansas until the commission issues a final order on the city of Tontitown's appeal, or the commission can elect not to adopt EcoVista's order. EcoVista will close its gates to this household trash, commercial trash, industrial trash in 2 weeks, probably at the outside. And Northwest Arkansas will be generating 1,500 tons per day of trash on the curbs, in the roll-offs, in the dumpsters, and the transporters who pick that stuff up are going to have to figure out some other licensed Class 1 facility where they can take it. And what you will not hear today is where that is, how much it's going to cost, and how the number of trucks and drivers in Northwest Arkansas are going to make that happen. They're limited by law by how much they can drive. As I mentioned before, the same truck that right now can drive up to Siloam Springs and back maybe twice a day with loads. It's not going to be able to do that. And that's kind of simply where it is, as we stand here today. There will be fines and delays at whatever nearest facilities do accept this material. Because like I said, you are shutting down 1,500 tons worth of trash disposal and kind of leaving it up to the transporters and those guys to figure out where to take it. So entities like the city of Siloam Springs, the Boston Mountain Solid Waste District, the city of Fayetteville wastewater and Northwest Arkansas Conservation Authority wastewater facilities. As you know, they generate sludge materials to operate, kind of where that material is going to go and where they're going to find the trucks to do that. We don't have an answer for that. There was a statement earlier about EcoVista polluting, and I think it's important for people to take a step back and realize the EcoVista Class 1 facility, the pollution is what it picks up on for people's curbs every day. And if you put your garbage can out there and expect a truck to come pick it up, that's the pollution in question. It's not something that EcoVista is generating. It's the industry and it's the commercial entities, and it's the residents nearby. And there will be service disruptions, and the commission just needs to decide is that acceptable or not. EcoVista has satisfied the legal requirements. We've satisfied the requirements for relief from the stay, and we respectfully request that the commission adopt EcoVista's proposed minute order. Ms. Goff already has a copy of it, but it's also on file. And unless the commission has any questions, that's all I have.
Sir. Commissioner Race, do you have any questions for Mr. Hang on. No questions, Commissioner Bell.
Counselor, do you have a representative from the landfill here today, management? Or can you answer the question? how many more years of storage do you have at the landfill as it sits right now?
I've been told by very experienced landfill operators that it's an art, not a science, because the volumes change.
Sure.
And maybe new locations open up. I think the existing application contemplates somewhere around 10 years of space, just building upon kind of like I said, the existing class 1 space. But I'm not entirely sure of that. And I am the best person available.
I didn't mean to put you on the spot, but I'm just, and it doesn't have a whole lot to do with here, but I'm just wondering what the life expectancy is. Secondly, what are their plans? This is a significant business. The city of Tawnytown derives revenue, the state derives revenue, the corporation derives revenue. They're gonna wait to 10 years and just walk off? Do they have any long-term plans? Do they have interim plans? And I guess where I'm going with all this is that, and I know people are not happy with how I've spoken about this issue, because I think we're really constrained by statute and by law. What are you doing to try to make yourself a better neighbor? Because I think I've seen enough to satisfy myself that it's not a good neighbor. And you know, should it ever been put there to start with, that's kind of leads back to the arguments I had in the last hearing we had, which is time to deal with some of these things is up front. And it wasn't. So now we're trying to keep the horse in the corral. And I've raised this concern in previous hearings. Is your client making a good faith effort to cooperate with DEQ and speak to these issues? Or is it just business as usual?
No, Ecovista has engaged on these issues robustly. They entered into an agreement with the city of Tawnytown that the city of Tawnytown freely adopted, which involved certain concessions, maintenance obligations that the Ecovista agreed to take on. I understand the commission has kind of repeatedly heard from several objectors to this, but there's been a hearing where the actual evidence as to some of the allegations you heard earlier, there are thousands of pages of groundwater sampling results attached to Ecovista's permit. There is an awful lot of data about these things, and it's been presented to Judge Bolton, and eventually a recommended decision will come before you. And that's not where we are today. Today you have a much narrower question, which is, do you kind of allow the status quo to maintain until a final decision comes in front of you, or do you want to shut down trash service in Northwest Arkansas?
Well, it doesn't have a whole lot of bearing on it, you're correct, but it has a whole lot of impact on the health, safety, and welfare of the public. And I've expressed my concerns about that previously. And so I guess I'm a little concerned that citizens are still making the same claims. And I'd like to know that you're being a good player in the community. So either you are or you aren't, and it all depends on the eyes of the artist. So I'll not belabor that. Thank you, sir.
Do you have questions? Mr. Vandergrift? Mr. Moss? Thank you. Before we go, Lisa, your name is on the agenda. Do you want to speak? Okay, thank you. I didn't want to go without you. All right.
Thank you for recognizing me for a second time today. I'm appearing before you now on behalf of Mayor Angie Russell and the city of Tawnytown. We also have an additional councilwoman here with us today, representatives of my client. We are here to oppose the lifting of the stay requested by Ecovista. Our primary issue is this request comes very late in the process. This permit is under appeal. We conducted an administrative trial in this matter right here in this commission room for several days, and we have since filed post-trial briefs, some excerpts or quotes of which I've included in a second packet, which is in front of you now. We await a recommended decision. from Judge Moulton on this permit, whether or not it can go forward at all or not. And seeking to lift the stay is generally something that happens very early in the process, not this late in the game. Now, we understand the rules allow for lifting of the stay in instances of economic prejudice, but here, the evidence is a single affidavit from a few weeks ago. In regards to the Class 4 permit expansion, we heard right at a year ago that they were nearly out of room there, but subsequent evidence came out during the hearing, indicated that they were not, in fact, using that space in such an immediate manner as that was needed. In fact, with the request that you have before us, I believe the affidavit indicated that they would run out of room in mid to late April. And we just heard a few minutes ago that they've got time for the next few weeks. Now, I'm not accusing Ecovista of fraudulent acts or anything of that matter. I can't imagine the difficulties in projecting waste stream volumes, the subsequent compacted mass, or projecting the number of months or weeks that are available in a permitted facility. I'm sure it's very difficult. Right now, they're asking you to change what is going on based on a single affidavit that really we haven't had much time to analyze, cross-examine, or do any sort of discovery or vetting of, because this lifting of stay is such a expedited proceeding. What I can say is this process is nearing a recommended decision, and I suggest being patient for one more commission meeting cycle is the prudent thing to do. I've submitted a minute order to you in the small packet that's in front of you as attachment 1, denying this request. Quite simply, there's just not a high level of evidence. There's no way to test the veracity of what is being said about when they will run out of time, out of space. And there, of course, are options. They can go to cards. They can take this waste elsewhere while we figure out what the future of this facility is and make the reasoned permitting decision that we hope is coming. In addition to the timing issues that I discussed above, I submit to you that it is also prudent to wait on ruling on this stay, or to leave the stay in place again, because the evidence and testimony presented by Mayor Russell in the city of Taneytown at trial is serious and significant as it relates to fire prevention and emergency communications, as well as groundwater modeling and monitoring. We brought in 2 recognized experts to the trial of this matter, Mr. Todd Thalheimer, a firefighter and engineer who specializes in landfills, and Mr. Steve Hart, a professional geologist with years of experience addressing all things pertaining to groundwater. The second attachment to the materials I provided to you excerpt some of that testimony highlighted in our post-trial brief on this matter. While I cannot, of course, summarize to you through a 3-day trial, I hope these excerpts will give you an idea of the deficiencies in this permit, which were highlighted at trial. For example, under number 1 in the emergency communications, Mr. Thalheimer has pointed out that there are no plans for an on-site fire response. There's no PPE requirements. There's no communications, internal communications requirements. There's nothing defined in the permitting materials on how to address an on-site fire. His problem with this is that leads to a small fire becoming a big fire, and I quote, based upon the simple fact that you're not providing communication. Now, also with that, communications, of particular concern to the city of Taneytown and its citizens is that there is no community notification in the current permitting materials. There's no way, and this is number 2, no means of communication and emergency to citizens exists. Mr. Thalheimer tells us that the fundamentals are lacking at this site. There's no written document for how the city of Taneytown Fire Department and the mayor's office is going to communicate with the site. There's no means or practicing of how they're going to notify citizens that live near the landfill on how something is happening, how to respond to a hazardous fire. These are serious concerns that Mr. Thalheimer has testified to that we don't want you to circumvent today by lifting the stay. Also, and I understand that this is a motion to lift the stay, and then next month will likely be when I get further into the evidence, but I just also want to point out that we have serious groundwater concerns as testified to by Mr. Hart. And I'm moving on to number 3 in the packet I've provided you today. Mr. Hart seems to have been the only geologist involved to review everything from about 1996 forward in this case. We have lots of instances of either individuals with DEQ or with the applicant taking a look at a very small element of what is going on. And again, this is what we can get into more next month, I hope. But to summarize Mr. Hart's testimony, it's his opinion that important facts regarding groundwater monitoring have been ignored over the years to continue to indicate in the conceptual site model for the site that the groundwater flows to the south or southeast, when in fact it is radial flow, as demonstrated by the most recent dye testing that showed dye in Wildcat Creek. And that's information that, and I'm moving on to the second page of under number 3, that ADEQ didn't really consider before issuing this permit. Nobody looked at that. I mean, that is a concern, both from a monitoring and a modeling standpoint. So our big point is that there has never been a proper conceptual site model of this site that just flat out says flow is radial. The last conceptual site model before this permit was issued said that flow was to the south-southeast, and that's what was considered during this process. They tried to change that a little bit in the permitting decision, and they've since come back and waffled a little bit, but that is the conceptual site model that existed at the time of the application. And it's our position that that has resulted in, and I'm on number 4 now, a failure to create a robust groundwater monitoring system, and the standard is to detect pollution as soon as possible. That doesn't exist here. I think that is demonstrated by the fact that every time a dye test occurs, especially this most recent one, it pops up in a new place in Wildcat Creek. So I urge patience in regards to this stay. Let's wait and see what the recommended decision is. Let's get all the facts, and let's come back and let's discuss what happened at trial and what the recommended decision is. But in sum, it will be our opinion that expanding a landfill in karst topography is not a good idea. About 30 years ago, there was a landfill proposed in karst topography in Pendle, Arkansas. They did a dye test there, and dye popped up in Mitch Hill Spring, some distance away, and that ended it. Here, it's really no different. We've had a dye test that popped up in a spring several thousand feet away, further than had been determined that the groundwater was connected before, and we hope that ends it. That we can demonstrate that the groundwater monitoring and modeling at this site is insufficient. So again, I urge patience. Let's come back when there is a recommended decision, and let's address the substance of this case and not change that. Mr. Heister said the status quo is to dispose of waste. We're going to say the status quo is to not dispose of waste in this new cell. And again, urge that the stay be reinstated and that we come back and make a decision on all the facts. Thank you for recognizing me.
All right, questions? Commissioner Racy? Commissioner Bell?
Yes, sir. You just said something that was very troubling to me in regards to coordination of the landfill and the fire department and not it being absent. Has the city made an attempt to reach out to the landfill and address this issue? Or are we just going to wait? I mean, I get your point, and I understand that, but that should be separate from this permitting issue. If there's a concern for the health, safety, and welfare of the public, I would hope the city and landfill will get together on that sooner rather than later. Well, rather than waiting for a decision on this or anything else in the matter. So I would encourage the city to deal with that. That does trouble me quite a bit.
We're hoping to deal with it. That's why one of the reasons why we've appealed this permit.
But I don't think that should be dependent on the permit. They're two mutually exclusive items. The city should reach, even if this is not permitted, you still have a landfill that's susceptible to fire. The city needs to deal with that, and the landfill needs to cooperate.
I agree, Your Honor, or Commissioner.
Thank you.
Commissioner McMillan, question? Commissioner, you can. Commissioner Moss, any questions? Okay. All right. All right. Commissioner Melton, you have a question?
Judge, we've circled back doing the same thing we've done before. This is a very narrow decision that we're expected to make. It's not a permitting decision. And I guess, I believe Councilman Nolan mentioned, he questioned the affiant in the the petition that, Mr. Heister presented. Will he be questioned, examined, deposed, or is that gonna be well after the fact?
Yeah, sure. Go ahead, Mr. Hester. Although he did ask me.
Well, I was trying to, okay, go ahead and then I'll.
Go ahead, Mr. Heister.
Judge.
The answer, I think, is we filed our papers over a month ago. We never received any request for Mr. Small to be deposed. And furthermore, the point was made about the accuracy. So everyone it's clear. Commissioner Melton temporarily allowed us to use space until this hearing occurred. That new space has been used. And so the initial estimate of mid-April remains accurate. It's only that we were temporarily allowed to use new space until today. And I feel like I have to make it clear, since there were so many statements about the record, that will come before the commission the next hearing. But the statement that this is karstography, it's not accurate. It's located on immature church. Dr. John Brahana from the University of Arkansas conducted groundwater investigations out at this site. Dr. Albert Bachman of MTSU both of them conducted years worth of groundwater and dye testing studies out at this site. The FTN's geologist spent thousands of hours. Dana Darrington, our professional engineer and professional geologist, spent over 2,400 hours investigating the geology and groundwater at this site just for the most recent permit application. And the city's experts spent 60 hours thumbing through the documents. We don't think it'll be a close call when you see the actual evidence from experts.
Any other questions or comments?
You vote in the affirmative will uphold the stay until such time as you can conduct your hearing and bring a recommendation back to the.
The hearing's done, Commissioner Melton. I've already had my hearing.
Okay.
And so, as council alluded to, I am in the process of writing a recommended decision for your consideration. I'm about 1.5 issues away of having that complete. I was kind of hoping that I would get it done today, but the day is whittling away here. You heard a lot of argument on the merits of the permit appeal. What you have before you is a request to either lift the stay or keep it in place. And the standard for determining that is, I think Mr. Heister alluded to, substantial prejudice. And that's in the law under 84205C6. And substantial prejudice is defined in that statute as actual harm to health or B, adverse economic impact, including without limitation, interruption, curtailment, or deferral of business or increased costs of construction or operation. That's what the law says in terms of either keeping a stay or lifting it because of substantial prejudice or the existence of substantial prejudice. So again, it's the commission's prerogative what you would like to do, keep that stay in place or lift it.
We have the motion before us. Are there any other comments or questions? Patty, would you call the roll, please? We don't have them.
So there, which motions?
This is the motion by Ecovista, by Mr. Heister, in which he filed asking that the automatic stay, that the relief from automatic stay is granted, relief from automatic stay. Am I correct, Commissioner?
That's correct.
And
that's correct, Commissioner.
He's the moving party. Patty, would you call the roll, please?
Richard McMullen,
Yes.
Doug Melton,
Yes.
Moss,
Yes.
Chris Racy,
Yes.
David Vandergrift,
Huge.
Wes Moore.
He's not here.
Absent.
So we have 4 yeses.
All right. So the motion is granted, approved. And at this time, I believe we have no further business before the commission. So we are adjourned. Thank everyone for attending.
Commissioners, don't leave, please. Let's get that, last minute order circulated for your signatures.